silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 17th, 2025, an officer was dispatched to a call for service at the 400th block of West Gray Street, Houston, Harris County, Texas.
Buckle up, guys. We're diving straight into courtroom reality, and the judge isn't sugarcoating a thing. In just 30 seconds, you hear the kind of warning that separates Netflix crime dramas from real-life consequences. One DUI, and you're already staring down jail time and thousands in fines. The judge's tone: cold, clear, and sobering. This isn't a lecture, it's a legal threat. It's the perfect storm of law, pressure, and a life about to change. Welcome to the docket, where the stakes are always high. Don't forget to like the video and subscribe to the channel, and we'll see you in the next video.
Arrival, the officer observed the defendant sitting inside his vehicle. The officer made contact with the defendant and observed the defendant to have bloodshot eyes, unsteady balance, and was confused. The defendant stated he didn't have anything to drink. A Houston Fire Department employee, the wheel witness, stated the defendant was asleep in the driver's side of the vehicle with his foot on the brake and the vehicle in drive. The wheel witness stated he had a hard time waking up the defendant. SFSTs were conducted. 6 out of 6 clues were observed on the HGN, 5 out of 8 clues observed on the walk and turn, 3 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were .179 and .175.
Where was he? Was he in the middle of the road?
It sounds like... Yeah, I know. So it says that he was sitting inside his vehicle on the 400th block of West Gray Street, which is accessible to the public. On a public road.
Oh, please. I have no idea what that is, where it is. Is he in the middle of the road? Is he in a parking lot? Is it Domino's Pizza?
Alright, guys, here's where the details hit hard. Passed out in a running car, bloodshot eyes, foot on the brake, and the vehicle in drive. Officers say he claimed he hadn't been drinking, but the breathalyzer told a whole different story, 0.179. That's not just drunk, that's legally explosive. And if you're thinking that's enough to seal the case, think again. The twist is coming, and it's the kind of thing that keeps defense attorneys employed. Don't forget to like the video and subscribe to the channel, and we'll see you in the next video.
It says, well, more specifically, it says 400 block of West Gray Street is a public street.
I need more information. I mean, does it say he's in a street there, or are you assuming?
No, I'm not assuming. I'm saying what it says is that the 400 block of West Gray Street is a public street. It doesn't say specifically.
It doesn't ask him if he's driving, doesn't none of that. I mean, really.
Yeah, he did have the vehicle in drive with his foot on the brake and was unconscious. But in regards to the location aspect of it, there's nothing further stated on that.
I'm sorry. I'm going to find no probable cause. I can't just go forward with assumptions here, you know? Mr. Cleary, be safe, man. You know, we have every single day. Look, this weekend, how many people died on the road here in Harris County? You know? Really. Be smart. You know, you have but one life. Don't do something where you either ruin your life or, more importantly, ruin someone else's life. Okay? Please take a seat, sir. I'm going to find no probable cause.
Alright, Judge.
This one will leave your jaw on the floor. Despite the suspect being unconscious behind the wheel with a BAC nearly twice the legal limit, the judge dismisses the case. Why? Because the prosecution couldn't prove where the car was parked, public or private. No assumptions allowed. In court, facts rule and guesswork crumbles. This is due process at its most frustrating, airtight charges undone by missing details. And just like that, he's free to go. Let that sink in. Don't forget to like the video and subscribe to the channel, and we'll see you in the next video.
Page 4, door, Adam.
Mr. Dory, you're charged with assault with a family member. You're facing up to a year in jail and a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Yes, sir.
Officer was dispatched to a disturbance. The complainant and the defendant are in a dating relationship. The complainant stated the defendant shoved her multiple times with his elbow and also grabbed her.
From DUI to domestic violence, buckle up, we're switching gears fast. Visible injuries. Scratches. A purple bruise. The victim says he elbowed and grabbed her repeatedly. The judge doesn't hesitate. Protective orders are issued, and the bond threat is loud and clear. So high your hair will fall out. That's not just frustration, that's controlled fury in a black robe. When evidence is physical, denial won't help you. This isn't a warning shot, it's a loaded gavel coming down hard. Don't forget to like the video and subscribe to the channel, and we'll see you in the next video.
Arm and a large purple bruise on her right arm.
Know that he hit her? Do we know?
So the complainant stated the defendant shoved her multiple times with his elbow and also grabbed her arm, causing pain.
Alright, Mr. Dorn, we're going to find that there's sufficient probable cause to go forward with your case. This case is 1,139 days old. If you take off again, I'm going to make the bond so high, you'll have hair falling. Do you understand?
Yes, sir.
As it stands now, I'm going to put an ankle monitor on you so I know where you are at all times. You will have the GPS monitor. I am now also issuing a protective order that you're not to have any contact with this person whatsoever. Miss Ray Perez is now a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under Section 42.072 of the Texas Penal Code.
The courtroom's tone just tightened. The judge slaps on a GPS ankle monitor, issues a no-contact order, and fast-tracks the trial to 30 days. Forget delays, this case is moving at full throttle. And the message? Clear, we're not waiting for you to mess up again, we're staying 2 steps ahead. Every second counts when public safety is on the line. And if you're in his shoes, this is the part where you find a lawyer fast, or get steamrolled. Don't forget to like the video and subscribe to the channel, and we'll see you in the next video.
Or grow within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
If you violate this protective order, the state can and will file a violation protective order if it's one of the worst cases you can pick up. Do you have a lawyer today?
No, sir.
What are you doing about that?
Need to file one.
Okay, we will give you time. I'm telling you now, I'm fast tracking this to trial. In 30 days, it's discovery complete.
Discovery, it looks like we are missing some photos potentially, but besides that, discovery is
If you can try to get on it, 30 days, I'm putting this case to trial. Do you understand? It would behoove you to immediately go out there and start trying to find a lawyer. I'm going to have you go to Victoria, sign a reset. After that, you'll get with Felicia for your bond conditions. I'm going to have you take a seat while we create all the documents while you sign it, and then you'll be free to go, sir.
Yes, sir. Yes, sir.
Mr. McIntosh, you're charged. You're on bond for a theft. You've now picked up a new theft. On the new case, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 6, 2025, an officer was dispatched to a shoplifting call at Walmart in Harris County, Texas. The officer made contact with the asset protection staff. The complainant stated that he recognized the defendant from a previous encounter. The complainant observed the defendant grab multiple items and attempted to leave the store, passing all points of sale without attempting to pay. The defendant stated he owned a Purple Heart Veterans discount, and therefore the amounts
That was the first step, right? I remember that from the first step. That's 254, right?
Right. So no, this is 255. So maybe similar facts.
No, that's the exact. Then that must be the exact same as the first one.
Let me check. Right. Yeah, that's my father. So the older theft is from December 16th, 2024.
Right.
And that was from Melrose, and this is from a Walmart, and this is on March 6, 2025. I'm not seeing anything on the previous theft regarding the Purple Heart discount.
Okay.
You need me to start over?
Just so, to Walmart and how much?
It's $283.62.
Judge, if you can recall, this is the young man that you had granted a pretrial. You had given a bond for him. You had me to talk to his mother to see if his mother would have a place for him to stay, and she said yes, provided that he puts up an effort to try to get a job and etc.
Oh, I remember that. Okay. But he now picked up a new case.
Now,
Have we addressed that since then?
Yeah, we addressed it. We knew that he had picked up another case. That's why you were upset that he had picked up another case while he was on bond for the previous theft. But the court was kind enough to still give him a bond because I had spoken with the mother, and the mother informed me that he could stay there and until such time that he.
Are we doing another arraignment today?
Yeah, bond conditions have already been set for this.
Why are we doing an arraignment? Is today just a regular setting then? I'm showing them both set for.
Door? It's I guess it was just a regular setting.
Don't-
Not a PR bond, and on the
Right.
bond, it had today's date of building.
If you pick up a third case, I'm going to absolutely lose it. Do you understand?
Yes, sir.
You must get a job or be in school full time.
Yes, Your Honor.
Do not use any illegal drugs. If I find that you're using, I will lock you up. Do you understand? We've given you now 2 PR bonds on the first one, 1 PR bond on the second case. That's 3 PR bonds.
Now we enter the long game, and it's not looking good for the defendant. Already out on bond for a previous theft, he's now back for shoplifting again. Same story, new receipt. The judge has had enough. 3 PR bonds, 0 progress. Pick up a third case and I'll lose it. That's courtroom speak for last chance. Now he's facing job requirements, drug tests, and a ticking clock. This is what the end of judicial patience looks like, and it ain't pretty. Don't forget to like the video and subscribe to the channel, and we'll see you in the next video.
Will not get another one. Do you understand?
Yes, Your Honor.
In the next couple of weeks, I'm going to send you for a drug test. If I find that you're using, it's not going to go well for you. Okay, so I guess let's set this case out for a couple of weeks, because I want to know what he's done to get a job. I'm setting your case out for 1 to 2 weeks. I want to see what you have done to get a job. If you have done nothing, if you come here and show me that you have not filled out at least 10 to 15 applications for a job somewhere, it's not going to go well for you. You understand?
Yes, Your Honor.
Alright, so 2 weeks, you're going to get tested when you come back.
Yes, sir. Yes, sir.
Alright, Jimmy, thank
Thank
you.
you, Your Honor.
Thank you.
Thank you, sir.
Ready, Judge? Yes. Approach on Mr. Perez for 1 minute.
Page 20.
May I call him up?
Yeah, please.
Ricardo Perez.
Is this all you have to take?
No, I've got other ones I need to talk about.
What is the case number?
It is 255-6010.
Buenos días, señor. ¿Nos puede decir?
Whereas you were charged with assault, bodily injury, you are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay, plan. Good morning.
On March 16, 2025, officers were dispatched to an assault with injuries located at 4000 Hollister in Harris County, Texas. The officers were unable to speak with the complainant because his injury caused him to be unconscious. Officers reviewed surveillance, which showed that the defendant pushed down the complainant with both of his hands, causing the complainant to hit his head first on the concrete. It also showed the complainant to be unconscious. The defendant was identified through a witness who called him out on the scene and identified him. And the defendant matched the person in the surveillance
Where
footage.
was this? At a bar? You're drinking? What?
It doesn't state, it just gives an address.
I believe it was at an apartment complex where he resides. My understanding. I guess we'll see what the surveillance shows.
Mr. Perez, I'm going to find that there's sufficient probable cause to go forward with your case. I want you to understand that I'm going to do everything in my power to protect my city at all costs. This is now your second assault within the last year and a half to 2 years. If I find that you so much as